Every year, millions of business owners form an LLC, believing it makes them untouchable. Their personal bank account is safe. Their house is protected. Their savings are off limits. Then something goes wrong. A lawsuit, a debt, a contract dispute, and they discover that the protection they paid for was never as complete as they assumed. This is a breakdown of what an LLC actually does, what it protects, what it doesn't, and the specific conditions under which that protection disappears entirely. This is not legal advice. This is how the mechanism works. An LLC, limited liability company, is a legal structure that creates a separation between you, as an individual, and your business as an entity. In legal terms, the business becomes its own person. It can own assets, enter contracts, take on debt, and be sued, independently of you. That separation is called the corporate veil, and it is the entire basis of what people mean when they say an LLC protects them. The theory is straightforward. If your LLC is sued and loses, the plaintiff can go after the LLC's assets, its bank account, its equipment, its receivables. What they cannot do, in theory, is come after your personal assets, your home, your savings, your personal vehicle. That boundary between business liability and personal liability is what an LLC is designed to maintain. But that boundary has conditions, and most business owners never read them. There are 4 things an LLC protects you from, and 3 things it does not. We will go through all 7, what an LLC protects you from. Number 1, business debts you did not personally guarantee. If your LLC takes out a loan and defaults, the lender can pursue the LLC's assets. If you did not sign a personal guarantee on that loan, and this is a critical distinction, they cannot pursue you personally. The LLC absorbs the liability. Number 2, lawsuits against the business. If a customer, vendor, or competitor sues your LLC for breach of contract, negligence, or damages, the lawsuit is against the entity, not against you as an individual. Your personal assets sit outside the reach of that judgment, provided the corporate veil remains intact. Number 3, claims from business partners. If a co-owner of the LLC is sued personally for something unrelated to the business, their creditors generally cannot seize the LLC's assets to satisfy that personal debt. The LLC structure protects the business from the personal liabilities of its members. Number 4, separation of financial risk. If the LLC fails, goes bankrupt, closes with outstanding debts, those debts belong to the entity, not to you personally. The business absorbs the loss within its own structure. These 4 protections are real. They are why LLCs exist and why they are the most common business structure in the United States. But here is where most business owners stop reading. LLC does not protect you from. Number 1, personal guarantees. This is the most common misconception in small business. When a bank, landlord, or vendor requires a personal guarantee before doing business with your LLC, and they frequently do with new or small businesses, you have stepped outside the protection of the LLC entirely. You have personally vouched for the obligation. If the LLC defaults, they come after you. The LLC structure is irrelevant the moment you sign a personal guarantee. Number 2, your own wrongful actions. An LLC protects you from the business's liabilities. It does not protect you from your own. If you personally commit fraud, negligence, or a tortious act in the course of running the business, you can be held personally liable regardless of the LLC structure. The courts do not allow the corporate veil to shield individual wrongdoing. This is why the CFO in our previous case file was convicted personally, not the company. The entity did not commit the fraud. He did. Number 3, piercing the corporate veil. This is the most legally significant risk and the least understood. Piercing the corporate veil is a legal doctrine that allows a court to disregard the LLC structure entirely and hold the owner personally liable for the LLC's debts or judgments. Courts pierce the corporate veil when they find that the LLC was not operated as a genuinely separate entity. There are 5 specific conditions that trigger this finding. Condition 1. Commingling of funds. You use the LLC bank account for personal expenses. You transferred money between personal and business accounts without documentation. You paid personal bills from the business account. Any of these creates evidence that the separation between you and the LLC was not real. Condition 2. Failure to follow formalities. LLCs have operating requirements, annual filings, meeting records in some states, maintained registered agents. If these formalities are ignored, courts treat the LLC as a shell rather than a genuine entity. Condition 3. Undercapitalization. If the LLC was formed with insufficient funds to cover its foreseeable liabilities, essentially created as an empty vehicle, courts have held that the protection should not apply. Condition 4. Fraud or misrepresentation. If the LLC structure was used specifically to deceive creditors or evade existing obligations, courts will pierce the veil without hesitation. Condition 5. Personal use of business assets. Using LLC-owned property, vehicles, equipment, real estate, for personal purposes without proper documentation and compensation to the LLC weakens the separation courts look for. Any one of these conditions, if proven, the LLC is not a set-and-forget protection. It is a structure that requires ongoing maintenance to remain effective. The business owner who forms an LLC and then operates as though the entity does not exist, mixing funds, skipping filings, signing personal guarantees without reading them, has paid for protection they have already voided. The business owners who benefit most from LLC protection are those who treat the entity as genuinely separate from day one. Separate bank account, opened immediately, used exclusively for business transactions. Operating agreement, drafted and signed by all members, kept on file, referenced when decisions are made. Annual state filings, completed on time, every year, without exception. Personal guarantees, reviewed carefully before signing, negotiated where possible, and tracked as personal liabilities when unavoidable. Business expenses, documented, categorized, and never mixed with personal spending. These are not complex requirements. They are administrative habits, but they are the difference between an LLC that holds up in court and one that a judge sets aside in 30 minutes. The corporate veil is only as strong as the discipline behind it. One final point that most LLC guides omit. Forming an LLC in one state while operating in another creates a foreign qualification requirement. If your LLC is registered in Delaware, but you operate primarily in Texas, you are required to register as a foreign LLC in Texas as well. Failure to do so exposes you to fines, back taxes, and in some cases, the inability to enforce contracts in that state's courts. This is a compliance gap that catches small business owners consistently, and it is entirely avoidable with a single additional filing. The LLC is one of the most useful legal tools available to small business owners, but it is a tool, not a guarantee. It works when you work it correctly. In the next video, we look at a real case where the corporate veil was pierced and what the court documents show about exactly where the owner lost protection. This is verdict paper. Every collapse has a paper trail.